I'm not an attorney. I just play one on TV. Just kidding. I'm Chad J. Carl, independent certified financial planner professional. Observing our in-house estate planning attorneys over multiple times, it seems as though there are 5 key legal documents that pretty much everybody should have. Number 1 is a will. If you've taken the steps to avoid probate that I had discussed in the prior video on estate planning and how to avoid probate, then all your will is going to be used for is to appoint what we call today a personal representative. Back when I went in, when I was in college taking law classes, they would call that an executor if it's a male, or executrix if it's a female. If you have, so basically with this, with your will, you can list one person as a personal representative to handle your estate. What you could do then is list a backup to that person, what we call a contingent, and then maybe you could list a third person, again, what we call a tertiary. Sometimes this is nice if you have multiple children. You can list, in essence, all of them, so that way nobody really feels left out, just because all of their names are on the will, even though that's all it is just for to list the personal representative. One of the most important documents, though, is the power of attorney for finances. This is required even if you're married. This appoints someone to make financial decisions for you, even if you're, if you're in a bad way. Our in-house accountant can't even file your tax return, or you can't withdraw money from your investments if you don't have a power of attorney for finances. Recently, I experienced a client who did not have this document drafted properly. She ended up hiring an attorney. It cost her over $10,000 in an excess of 3 months in order to have it. Basically, she had to have what's called a financial guardian appointed in the court system in front of a judge. So it's a very expensive and difficult process. The third most important document is a power of attorney for healthcare. And again, this is required even if you're married. And this appoints someone on your behalf to make healthcare decisions or even obtain medical records under the HIPAA law if you're in a bad way. Again, a good estate planning attorney will draft this to be more comprehensive than just some of the free online documents that are available or that hospitals quite often provide. 4 is what's called either a declaration to physicians. Some people call it a living will. Some people call it an advance directive. And that just basically states that if you're on life support with no chance of recovery, your desire to discontinue a treatment. And then number 5 is, lastly, over half of the states have now adopted a special deed that I call a beneficiary deed, what a lot of the attorneys call a transfer on death deed, or TOD deed, that an attorney can draft typically and file with the county that your property is in, so that property will avoid probate. So call us today for a free chat with our in-house estate planning attorneys to explore your situation. And be blessed.